and one day to be part of this EU and NATO organization. Thank you.
Okay, thank you, Mirjana. And now is the turn for Sandra Gudaitite, if I spell it correctly, who will speak for a very interesting topic, gender-based violence as a weapon of war. Let's listen to her.
First of all, I would like to thank the organizers for the opportunity to talk here today in Badar University. It's a great initiative which allows us to present our thoughts and ideas and probably to contribute in answering many questions in human rights. My topic, the one I've chosen today, is one of the examples where many questions are still to be answered, and until those questions will be answered, there will be a lot of unclarity and a lot of doubt in prosecuting sexual violence as a weapon of war. Sexual violence has undoubtedly been used as a weapon of war for ages. It's not been an exception in ex-Yugoslavia and Rwanda. For example, there was a wide propaganda in Rwanda against Tutsi women, and people were encouraging to use sexual violence against them as a tool of weapon in order to diminish their honor, diminish the Tutsi women honor. So, having established that sexual violence has been widely used as a weapon of war, one can ask the question, what protection can be offered by international humanitarian law? What protection can be offered by human rights law? And is it possible to prosecute these offenses under the auspices of international criminal law? These are really serious questions that have been answered in international criminal tribunals, especially International Criminal Tribunal for former Yugoslavia and International Criminal Tribunal for Rwanda. Rape has been forbidden under the auspices of the Fourth Geneva Convention and the additional protocols, and also has been acknowledged as a war crime in Furungia and Delilah cases in the ICTY. However, we have the first problem. There is no definition in the ICTY or ICTR statute of what is rape. So if we don't know what is rape, how can we indict people for something that we don't know what it is? Fortunately, ICTY already in its first case, the prosecution against Akeyashu, I'm sorry for mispronouncing, tried to solve this issue, and they introduced a really very important notion of what is rape. They said that rape is a physical invasion of sexual nature committed on a person under circumstances which are coercive. So this means that the tribunal stressed the coercive part of the definition. However, no matter how important this definition is, there are a lot of criticisms already. For example, the tribunal was analyzing this definition in the auspices of notions of inhuman acts, serious bodily and mental harm, and outrages against personal dignity. These notions are not being defined themselves. So how can you define what is rape with the notions which are not defined themselves? This means that it might be a situation when a person will be indicted for a crime which does not fall within the statute of the ICTR, which means we will violate the core principle of international criminal law, nullum crimen sine lege. It means if there is no crime, you cannot indict a person. Another criticism is that ICTR, in this case, tied sexual violence with the process of destruction. Some scholars say that it's too heavy, that in order to indict a person for rape, you need to prove that it's been meant to destroy the whole population. No matter these criticisms, further cases have adopted this definition until the ICTY in Kunarak case decided to let the coercion go, and they decided to tie the notion of rape with sexual autonomy. It means that it has to be analyzed whether there was a consent of the witness in any form. This means that the tribunals have shifted from the notion adopted in the Akiyasu case and decided not to apply the requirement of coercion, and they were analyzing whether there was a consent of the witness or not. This notion, this new notion, has been reaffirmed in many further cases, until in Muhimana case, the court says that war crimes are of coercive nature themselves. So how can you separate coercion with voluntarity? They say that these two notions are tied. This means this coercion, the requirements of coercion, has been reintroduced again. So there have been three important steps that have been made. Once court introduced the requirement of coercion, then it shifted away and said, no, we need to look at sexual autonomy. And then they came back to the requirement of coercion. This means that there's still no significantly established and uniform notion of what is rape. Why it is so? Why courts, after analyzing so many cases, still are not able to find what is rape? Like, sometimes it seems like why people can't find out what is rape and define it. So I have to stress that these international tribunals, they are based on the principle compétence de la compétence, which means that they have the competence to define their own jurisdiction. They are not obliged to follow each other. They are not obliged either to follow their own cases. Since there is no uniformity, we still have a lot of problems in defining what is sexual violence, what is rape, and this might lead for the prosecution the not willingness of the prosecution to indict people for rape, because they don't know what it is. So how can you indict a person if you don't know what the crime is? Now, some clarity might be offered by the newly established, well, not that newly established, International Criminal Court. The Rome Statute and its Article 8 is really significant, according to my opinion. It introduces much more crimes, not only rape. It says that sexual slavery and forced prostitution, forced pregnancy might also be constituted as sexual violence. It's really significant because it expands the long-established tradition that sexual violence is limited only to rape. However, court in the elements of crime introduced the notion of what is rape. It means that ICC took a lesson from the practice of ICTY and ICTR and said, no, we are introducing the notion and we are avoiding a lot of problems these two courts had. But they introduced a new notion, and they said that they tied rape with a genuine consent. What is genuine consent? This phrase has not been yet subject to judicial interpretation. Thus, we still don't know what it is. It means that ICC has been left in the same situation as ICTY and ICTR, without any possibility to say before indicting that, yes, we know what's rape, what's sexual violence, what's enforced pregnancy, or what's sexual slavery. They are still have to answer these questions. Fortunately, there are a lot of cases, well, there are a few cases, where sexual violence has been indicted. One of these cases is the prosecution versus Jean-Pierre Bemba Gombo. It's a really very significant case. This case has the most victim application of all cases in the ICC. There are almost 4,000 victims already acknowledged, and at least 1,000 applications where the victim has been acknowledged being raped or other form of sexual violence has been used against them. Thus, this case is will be a cornerstone defining what is sexual violence, what is rape, and we will hope that this judgment will offer some clarity. Personally, I think the ICC has really great potential to establish uniform practice of what is sexual violence, what is rape, to indict people for command responsibility, to introduce JC, individual responsibility, and other modes of responsibility. Yet, many questions to be answered. What is rape? What is sexual violence? What is genuine consent, whether it's needed at all? Well, many questions to be answered, and we are looking forward to these answers. Thank you.
Thank you, Sandra. And now is the time for you to ask if somebody have any question for each of the speakers.
Thank you. Ms. Margarita, I don't have actually a question for you. I would like to just say that was excellent, a really interesting topic, and then we face almost every day that usually the court just takes a side of a mother without even sometimes thinking if that's the best choice. So it's something I would say unusual approach, and it's really, really interesting, and thank you for bringing that up. I have a question for you, Ms. Minochkina. While doing your research, did you actually have found positive cases where maybe new laws, anti-domestic violence laws, actually brought some success? You know, some new data, maybe 5 years later of the new law being implemented, then domestic violence goes down or still remains same. Any positive cases while doing research? That would be good to know.
Thank you for the question. Yes, for sure. And the first positive trend is that actually these laws were adopted in the countries of the region, because largely the wave of adoption of these laws took place in 2005-2006, and largely due to the involvement of international community. The implementation of those laws reduced largely the case of domestic violence at first because it criminalized it. Before it was not such a notion that home violence, home abuse is a crime. And due to the domain of patriarchal culture in the region,